You may proceed.
May it please the Court, good afternoon. I am here on behalf of Donald Graham, the appellant in this matter. Mr. Graham was convicted in 1995 of the crime of first-degree murder and sentenced to life imprisonment, where he is presently serving. This matter is before the Court on appeal of a petition that was filed in the single justice session under Chapter 211, Section 3. There were two issues that were raised in the petition. One issue looks remarkably like an issue that was raised in the direct appeal, and I want to address why it is not the same issue, because I think the single justice who considered the issue treated it as the same issue. I think the Commonwealth treated it as the same issue. It is not exactly the same issue, although it certainly touches on something very similar. Essentially, this was a case in which the trial judge, while the jury was deliberating, in response to some questions from the jurors, gave them a supplemental instruction and determined that he would give the jury a tape of the supplemental instruction. The supplemental instruction, this was a murder case. There was an element of self-defense. There were serious issues about what degree of homicide it would be if the jury was going to come back with a guilty verdict. And in fact, the jury was out for a considerable period of time and asked several questions during the course of its deliberations. The trial judge had given an erroneous instruction on involuntary manslaughter during the course of the original charge, which he caught and corrected during the course of the original charge. It was raised, and that was corrected, and that was cleared up. When the jury came back for questions, they were asking questions about the elements of the offense. And the trial judge gave a re-instruction on the elements of the offense, decided that he was going to give a tape of the re-instruction, and recognized, I think sensibly, that he didn't want to give them a tape of the portions of the instruction that were erroneous from the earlier part. So rather than give them a tape of the entire instruction, he only was going to give them a tape of the supplemental instruction, which he did do over the objection of defense counsel. And this is where the issue, I think, gets somewhat confused between the original appeal and why we're here today. When this matter came up during the conference with the judge, as this issue came up during the trial, defense counsel specifically said that he objected to the giving of the tape because he was concerned about the jury highlighting portions, not hearing the entire instruction, etc. The trial judge, in response to that objection, said, and I quote, and this is reprinted in the brief, and this language is important. He said, "Well, I hear you on that objection, and it's overruled. Your rights are saved in that regard." He then went and described for several lines that are reprinted at page 8 of my brief what he was going to do. And at the end of that, he said, "I'll hear you at the sidebar when I'm finished, but your objection to my giving them the tape at all is noted and reserved without further ado." Okay, so he sends the tape. It's the position of the defense that the tape is not adequate. And the reason why the tape is not adequate, because it does not include an extensive or adequate instruction on reasonable doubt. It's true, the judge does tell the jurors in the tape that they need to consider all of the elements beyond a reasonable doubt, but he doesn't describe reasonable doubt again, and he purports to cure that by telling the jurors that everything he said in the earlier instruction, the portion they don't have.
And why isn't that enough? Otherwise, we would have to give all the whole instructions from the beginning to the end. Why pick out one? Why pick out reasonable doubt? Why not also give presumption of innocence? Why not also give indictment doesn't mean anything?
And I think that's why this court, in the Bacelar decision, decided not long before this case was tried, specifically described the procedures that need to be followed when giving a tape. And one includes giving a complete instruction. And giving the complete instruction, all of the instructions, not just what gets highlighted in the supplemental instruction, not a portion of the tape. I'm sorry, Your Honor.
Mr. Dickinson, whatever the nature of the particular claim made concerning the instructions to the jury, the taped and the non-taped part, when we reviewed this, we did so under 33E, which means that we reviewed the jury instructions, we reviewed the claims made with the tape. Why is that not dispositive? Not whether it was waived or not.
Okay, and I understand. I think I understand your question. I hope I understand your question. And I think what happened here, Your Honor, and I will say, when you review the trial judge's decision at the time of the motion for new trial, the Rule 25 ruling,
right,
The trial judge recounts the colloquy with counsel, in which he said what he was going to do. He told counsel he was going to give them an opportunity to object at the close of the supplemental instruction. But he omits from his summary the assertion that's included in the trial record that your rights are saved in this regard without further ado. And he goes on to say that the issue that's asserted in the Rule 25 motion, the error in the charge, was not properly before him because it wasn't properly raised.
Oh, I understand
I know
that,
it, but the point is,
we looked at it.
we looked at all that, and we found no substantial likelihood of a miscarriage of justice.
And I think the problem, Your Honor, was that it should not have been considered under that standard, because the trial judge's recounting of the colloquy, I submit, is a misleading recounting, because it suggests that the issue was not properly raised, when in fact the trial record reveals quite clearly that the trial judge told defense counsel, your rights are saved in this regard without further ado.
Refresh my memory. In the conference, the objection raised was to sending the tape in. Sending any tape at all.
Sending a tape of the supplemental instruction, not sending any tape at all.
Okay, but the objection at one of the claims in the motion for new trial was sending in was a different claim than that, right? That's the one that was preserved.
Well,
What?
I don't think it is I think it's the same claim. I think the trial judge treated it as a different claim. And I think the trial judge, in his decision on Rule 25, conveys, first of all, recounts the colloquy, but omits the portion of the colloquy in which he says to defense counsel, your rights in this regard are saved.
So he denies the motion. It comes up here. It's not argued as prejudicial error by his appellate counsel. Is that right?
It is argued as prejudicial error. It is raised on appeal, and it's treated as if it wasn't properly preserved and considered under the no substantial miscarriage of justice standard by this court, as if what the trial judge had said in his Rule 25 ruling was accurate, as opposed to what I think the record plainly reveals, which is that was inaccurate. Now, exactly what happened when this court physically, mechanically reviewed the record, I can't say.
So
but
what
I can
you're
say
suggesting is whoever wrote the opinion in this case may have, for better or worse, overlooked the fact that it should have been a prejudicial error standard.
And in candor, it may well be that appellate counsel did, well, the appellate counsel argued it as if it was properly preserved, but did not reprint for the court that portion of the colloquy.
Doesn't have to.
No. But he did argue it as if it had been properly preserved, and he contended that it had been properly preserved. But I do think, in fairness, if one read only the Rule 25 decision and did not go back to verify that the judge's recounting was an accurate recounting.
Well, was there a transcript of the instructions to the jury?
I'm sorry, Your Honor.
Was there a transcript of the instructions to the jury?
Oh, yes, and that was certainly with the court record when it came up here on direct appeal. I mean, I can't, it was certainly available to everyone at that point.
Right.
I don't deny that. It was available to appellate counsel, it was available to the Commonwealth, it was available to everyone. And that's why it's an unusual case, the argument that we're making, and I recognize that. And I think that's why it's important that it be carefully scrutinized, because here we have a
Let's assume that we use the prejudicial standard, right?
Yes, Your Honor.
What's the difference in the outcome?
Well, I think you have to look to the fact that the trial judge did not comply with Basilar, with the specific instructions that this court gave in that case. And the evil or the danger that this court contemplated in that case exactly is what could have happened here, or what did happen here, which is that the jury accentuates, elements of offenses without having reiterated the beyond a reasonable doubt standard, and is not only given portions of the charge, but portions of the charge, because it doesn't have the charge as a whole, and that counsel did object to it, and it's treated as if counsel did not object to it, and so we would submit that this was a close case. This jury was out for a long period of time.
For how long was the jury out?
The jury was out for parts of 3 days, I believe. They came back with several questions, including this one. They were clearly having problems, dealing with the elements and with with the facts of the case. And, you know, this is, and as I say, it's a serious case. And for those reasons, we would submit that, that the petition ought to be granted. I have raised another issue, and I am not waiving it, but I would rest on the brief on the other issue.
Thank you, Mr. Dickinson. Ms. Stern?
May it please the Court, Shoshana Stern for the Commonwealth. As described in the Commonwealth's brief, the judge in his Rule 25 decision clearly held that the defendant did indeed object to his instruction. What he found was that the defendant did not preserve the objection that he was then arguing on appeal. He said, I don't believe that this would have alerted any judge to the issue the defendant now raises. He says the defendant objected. He does not say, and if only he'd objected later, he would have preserved his appeal. He says the defendant objected. I overruled him. Unfortunately, I don't think he raised this issue. If he had raised it, I would have dealt with it. And this court said fairly plainly that we agree with the trial judge that the objection was not sufficient to alert him to the issue the defendant now raises.
What about what Mr. Dickinson refers to as quoting from the transcript, where at sidebar the judge said, you know, I'm preserving your rights, or words to that effect?
Well, he doesn't say that he didn't preserve his rights to that objection in the Rule 25 decision. I mean,
And we concluded it was a different objection.
yes, that he preserved it. The defense counsel said, this is the only reason I'm objecting, is that I'm afraid that they're going to pick and choose what they listen to from this, which is sort of the opposite of I think they need the whole thing. And that's what he said. And he said that you can object at the end if you have issues with the instructions I give to the jury. But he didn't say you need to object again if...
Oh, I mean, that's one way to read it. I mean, so what was the proposal? I mean, at the when the defense counsel says the only objection, and I don't have an objection to the court's reading, I think, would have an objection to the tape recording being sent up to them because what is that tape recording in that sentence? Is it just the portion?
I believe it's just the portion in that context, because that's the only tape recording that anyone is contemplating sending them at that point. And he says, well, I'm concerned because it's a microcassette recorder. I'm afraid that they'll only listen to parts of it. And the jury had asked several times about that particular set of instructions, and the judge said, well, I'm only going to send them these because that's all they've asked about. And what they requested was a written transcript, and they didn't have that. So
Right, no, I understand that.
And this court did not reach the issue of whether Baszler even applied in terms of requiring the full recording in this particular circumstance where it was in response to the jury instruction. But
Was Baszler even argued on appeal?
oh yes, it was argued on appeal by both sides.
Yeah, that was it.
But it was argued, and this court spent, in its opinion, a good deal of time recounting the facts that went into the whole the colloquy and the discussion about whether it was appropriate and what they were going to do.
Ms. Stern, I haven't frankly gone back and looked at the Graham decision and its discussion of Baszler, but let's assume that you. If I were to read that, would I be alerted to the issue that Mr. Dickinson is now raising, namely that there appears to have been a mismemory by Judge McHugh when he talks at the Rule 25 hearing, or if we look at it, if we go back and look at the full jury instructions and we go back and look at what we wrote at Graham and we go back and look at what we have before us now, we would again see that our description of the facts has been consistent throughout. That's a very long-winded.
Are you asking about specifically this court's decision?
When you get this petition, and you know the Graham case better, I mean the Graham opinion, did it appear to you as a kind of, oops, the SJC seemed to have misunderstood what was happening here, or was it rather, this is precisely what the SJC was dealing with, or was it something else?
Yes, Your Honor, my impression was that the SJC properly read that the trial judge related what occurred accurately.
So if you take the transcript at the trial and the transcript at the Rule 25 hearing,
Yes.
and you put them together, it's the Commonwealth's position, I mean, I know it is, but I mean, we'd have to look at it, that what Judge McHugh is reciting happened at the trial is in fact correct.
Yes, Your Honor.
And it didn't overlook something else.
No, Your Honor. That is the Commonwealth's position.
And that is because the nature of the objection was he was objecting to the tiny piece going in. I mean, the only one piece of the instruction going in by tape, he being defense counsel, not you should be sending the whole thing in.
Yes, Your Honor, and indeed the judge issued instructions to the jury saying you must freely let everybody listen to as much as you want.
Of the shortened version.
Of the shortened version. So the instructions he gave indicated that at that time he thought that that was defense counsel's objection. That somebody might hog the tape player and they might focus
but
on.
that doesn't help me because
Okay.
if defense counsel had, if there was a proper preservation of the objection, unless the whole tape went in and the judge decided that he was going to send in this piece of the tape, then that instruction, and if the judge thinks that,
Yes.
that he has already said your objection is preserved, that'll often happen. If the objection is preserved and the judge then
That's-
turns
yes,
to talk
that's
to the
true.
jury, you're going to have what's consistent with the judge's ruling.
Yes, Your Honor. But yes, I think that
You're saying if we look back at the transcript, nobody was arguing that the entire tape should go in.
yes, Your Honor. And one would imagine that this court,
Whose suggestion was it that this piece of the instruction go in?
I believe it was the judge's, Your Honor. It was
And was it because he was concerned that he'd given a misinstruction?
No, it was because the jury wanted a written version of all of the different possible verdicts because they requested one. They said it has to be made clear what all the options are. And he said, well, we don't have that, but here's what I'm going to do. I'm going to make a tape recording of this section. I'll send it to the jury. I will instruct them on how they are to use it and that they are to give full account to everything else they've heard. It doesn't change anything they've heard. They should use it in conjunction with the other instructions.
So he then went and made a tape recording?
Yes.
Okay.
He instructed the jury and had it recorded as he answered their question by repeating the instruction for, I believe, the third time.
Thank you, Ms. Stern.
Thank you, Your Honors.